Are live.
Welcome to the House Judiciary Committee this Thursday morning, April 24th, and we're continuing to take testimony on S12 sealing and expungement bill. And I believe we're starting with Marshall Paul. Marshall, thank you for being here.
Thank you very much.
You're also on the screen. Thank you. It's like, what?
It's assuming that I can figure out how to share my screen. I usually can't.
Sorry, Marshall. Oh, please.
Stand up. Thank you. Give me there, I got me there. All right. Yeah. Thank you. So, good morning, Marshall Paul from the Office of the Defender General. And S12 is an interesting bill because you guys have seen a lot of sealing and expungement bills over the years, and this is neither the best sealing and expungement bill that you've seen nor the worst. Sort of in the middle, and so I'm going to explain what's good about it, what's bad about it, and what could be changed to make it better. And sort of in a nutshell, here are the issues that our office takes a particular interest in, which are, first of all, S12 eliminates petition-based expungement. We think that's a bad thing. We think that petition-based expungement has been good, is getting better as technology improves and our ability to actually process expungements improves. And so I'll talk about that in a minute. It also, S12 moderately increases the scope of offenses that are eligible for petition-based expungement, or not expungement, but sealing. So I'm referring to confidentiality provisions when I'm talking about sealing and expungement sort of interchangeably. So S12 moderately increases the scope of offenses that are eligible, and that's good, but it's not nearly as good as the increase that was proposed in H762, which was a bill last year that was sponsored by Representatives Oliver and Ghostland and perhaps some others on this committee, and did not get a hearing, but was actually expanded the scope of confidentiality provisions much broader than is under current law or is contemplated under S12. S12 offers some control over the access to sealed records, but that control could be improved. S12 eliminates expungement for people who have been found not guilty. And to me, that's problematic because if there's anybody who deserves actual expungement, it's people who are actually not guilty. People who have been found not guilty by a jury should be able to have their records expunged. That they should not be given some half measure. Those are the people I think who most deserve to have their records expunged, people who were not guilty in the first place, as opposed to the expungement scheme that we have that is for, the petition-based expungement scheme, which is for people who are either found guilty or pled guilty and then have served their sentence. And then S12 moves backwards in terms of providing for automatic sealing or expungement, automatic confidentiality. And last year's H762 actually provided an immediate framework for some expansion of automatic confidentiality provisions. And we don't want to see things move backwards in that regard. We'd really like to see the expansion of automatic sealing or expungement. So to begin with, our first concern is simply the elimination of petition-based expungement. Petition-based expungement is the gold standard. It means that the physical destruction of all the files related to a charge. That's important for a lot of reasons, but most importantly, it provides actual confidentiality. When records are sealed, they are kept. They're kept electronically, they're kept physically, and people still have access to them. And whenever that's the case, you don't actually have confidentiality. If you just go on the internet, you can find all over the place that large institutions, in particular, state governments, state judiciaries, hospitals, educational systems, have all been the primary target of what they call ransomware hackers largely coming out of North Korea, Russia, Belarus. And so there's been states all over the country who have had their judiciaries, computer systems hacked, their data downloaded, they get threatened with a ransom. Most states are not actually even allowed to pay the ransom. Technically, paying the ransom works. The hackers that do this, if they take your data and they threaten you that they will expose your data to the public if you don't pay them a handful of bitcoins. Yes,
I just have a question on the data integrity aspect of this,
Yes.
Marshall. Is there evidence of that actually happening here in Vermont?
not in Vermont,
Okay,
but in Kansas. In fact, I read the article about Kansas's judiciary's computer system being hacked. They could not pay the ransom because they
yeah, no, I get that it can happen, but it's not happening here.
I expect it to. We've had, the University of Vermont Medical Center through a major ransomware attack where their data was compromised. And what everybody tells us, we just went through the process of changing over our case management system from one to another. And in that process, we had a lot of consultations with computer security people who told us it's not a matter of if but when, and that the state of Vermont systems are actually under attack every day, that every day there are bots, hackers that are attacking our system, and they are not getting through that we know of.
But that's our country. That's the
It is.
the technological
And that
infrastructure
is-
the challenge that we have.
And that's where I say that one of the things that's important is if we have data that we want to keep confidential, we actually need to be taking measures that we did not take in the past to keep that data confidential. I do it with my own data. I'm a lot more careful now about my own personal data and how it's stored on my computer, what goes into the cloud and where it goes than I used to be. In the early days of the internet, I just put everything on the cloud. These days, I'm a lot more careful about that because I've gotten 4 or 5 notices from banks and from a hospital saying your data's been compromised. It's now in the hands of hackers, and there's nothing we can do about that. And what we're told when we were doing our most recent software transition was you need to be careful about what data you're keeping. Don't keep data that you don't want the threat of it being exposed to the world. And so that's one of the things that we have to account for in this. It's really a new threat. From the time we started talking about expungement in the legislature, when I started doing this 10 years ago, we were really talking about paper file expungement. Basically, none of us had computerized files at that point. And at this point, we're all on computerized files. So even though we're still talking about some of the same issues in expungement, the context around it has dramatically, and the importance of being able to actually delete data in a way that makes it not recoverable or not accessible is more important than ever.
Another one. So Marshall, not to interject in, your meditation here. I know that you prefer to be
I
interactive.
prefer to be interrupted. I didn't know this.
And so on the and we won't want that. On the second bullet, sealed records are not destroyed and can continue to be used and accessed. I mean, that's exactly what proponents of this legislation are advocating for, and why we think that sealing, is beneficial in lieu of expungement. So I'm just kind of curious what your thinking is on why sealing would not be sufficient enough, like why we should destroy records, and that could be, and like we heard testimony yesterday, that would potentially be extremely relevant to future cases and if there are future interactions with offenders.
So the fact of the matter is that evidence is mostly anecdotal, and this has been studied. So there are studies about the relevance of criminal record information and how long is it relevant for? How long does it provide any predictor of future behavior? And those studies really depend on, it shows that it depends on the type of offense and type of offender, but there is a period at which there is no predictive relevance to past information, even though everybody wants to believe that there is. And I do it myself. I mean, I have to check myself as a defense attorney. I often look at a client and I look at their record and I make assumptions about their current charges based on what their record is. I look at, I have a client, they're charged with something, and before I even meet them, I see their criminal record and I start to make some assumptions about, oh God, this is somebody who's got these things in their background. I bet this is what I'm going to find when I start to investigate their case. And part of the reason why it's important for me to check myself is because so often those assumptions prove to not be true. And what I found is actually that my gut instinct, which is that people's past records are predictors of their future behavior, is really not actually true. And that what the studies have shown, which is that people who engage in nonviolent but antisocial and criminal conduct, that tends to sort of have no predictive value after 3 years. People who engage in more violent, more interpersonal but non-violent conduct. That conduct tends to have no predictive value after about 5 years. And even for people who have engaged in serious violent conduct, it loses its predictive value around 10 years. And I realize that because I have clients who I go into predicting, this guy's trouble, looking at their background. And then when I investigate, what I find out is this guy's in trouble because everybody's presumed that this guy is trouble because of his background. That's why the police focused on him. That's why the community reported him. That's why his stuff came under scrutiny in the first place. So from our perspective, there comes a point at which records should be eliminated, no longer available, particularly records of non-conviction. We're talking about various types of records here. A lot of the records we're talking about are not actually records of conviction. They're records of people who are arrested, and the prosecutor looked at the affidavit and decided, this doesn't actually allege a charge. I'm not going to charge it. We're talking about those records. We're talking about charges where they were charged, but then a judge looked at it and said, there's no evidence to support this charge. I'm throwing this out. We're talking about those records. We're talking about a lot of different types of records, not just records of conviction. So in terms of the scope of S12, S12 expands the scope of confidentiality provisions, but it does so only modestly. So under current law, and this is an estimate, and I say that because it's interesting. Trying to count the number of felonies in the state of Vermont is a really difficult thing to do. And so I based this list on some work that Crime Research Group did in 2014 when they put together a list of all offenses in the state of Vermont for the Criminal Code Reclassification Project, which, just to plug that was a really great project. As sort of a guide, it would be a really good thing if that was reinvigorated. All of these situations where I'm in here talking about the fact that we don't even know how many crimes we have in the state of Vermont, those are problems that would be solved by the Criminal Code Reclassification Project if it was to be reinvigorated. I know that's not part of this bill, but it was part of this research, so I wanted to put in a plug for it. But so based on that 2014 data, plus my quick accounting of the bills that have happened since 2014 and the added and subtracted felonies since then, I estimate we've got about 267 felonies on the books in the state of Vermont. Under current law, 240 of them are not expungible, and about 14 of them are expungible. Under S12, that would expand, but only modestly. So there would be about 35 expungible felonies under S12. But under H762, which was the bill, that didn't make the whole thing go away good, which was the bill from last year that was here in the House, 192 of the felonies would have been sealable. And only 62 felonies would have been not sealed. So just in terms of what this bill does in comparison to what H762 did last year, H72 went much farther in terms of its scope of what it applied confidentiality to.
Here.
Just for me, pointing out the difference between the two, I appreciate it, and that bill did not pass. And so I feel like we're trying to find a compromise in it with this. So I don't know if you can speak to that at all, because like that's the line that we're trying to do is find a compromise that's going to work for everything. So we can agree like some bills were better before, but what's the path that we can take now that everybody will support so we can get it out the door?
And just to be clear, 762 is not the bill from last year that didn't pass. 762 is the bill that didn't get hurt. There wasn't testimony about 762.
It still didn't pass,
So,
right?
yes, it didn't pass. Yes. my point is simply to just point out what was on the table last year and sort of where this bill fits in that. And my point is that I think that this bill, S12, could be better. I don't think it's, as I said at the beginning, it's not the worst ceiling and expungement bill that the committee has seen. It's not the best either. And I'm just trying to give some perspective on how it could be improved. And the scope of it is one. So
I'm sorry, if I might, and I'm guessing your presentation is going to include it, but I think if there are specific suggestions that you have
certainly,
of how to navigate that, knowing that we're trying to manage all the different needs in this.
and I think that the language from, when it comes to the scope of confidentiality, the language from H762 was fantastic, and I would recommend it. It was language that was introduced by Representatives Gosselin and Oliver, and I think that it was broad and expansive, and we were supportive of that, and we continue to be. So if we're looking for a source, that's what I would point to.
But is that listed in the presentation or we need to
No.
pull it out to reference it?
But I have it from last year. It's just in H762 from 2024.
Okay, and are there any specifics to it that we could?
Sure. I mean, I think that the provision on
I don't mean to interrupt, but my understanding is that the way 762 proceeded was it essentially said everything's expungable except the following.
yes,
What we passed last year and what is in this bill is that's what we do with misdemeanors. But then for felonies, we list the felonies.
yes.
I don't see us going back to 762, but if there are specific categories of felonies or if there are additional felonies that you think that we should have in the list of felonies, that would be helpful because we're not going to go, I don't perceive, given what happened last year, that we would be going to this other approach.
And I think that if we move to the approach of saying nothing is going to be expungable or sealable except, it gets to the point where I'm not sure why we're doing the bill. The bill reduces the level of confidentiality from expungement to sealing, which is a less confidential status, more at risk. And if we're also saying we're also going to be continued to limit based on, an exclusionary rather than an inclusionary list. So we're saying nothing is sealable except the following. I feel like we're moving backwards in terms of both scope and confidentiality at that point. I think.
So
From my perspective, the idea of saying everything is expungible except those things that we have identified as where we need to have that information in the future, that's the right approach. That's the way that we should be approaching this.
fair enough. Karen.
I guess because I agree, like if we're not seeing the same goal for the bill, like it's gonna be frustrating because we're gonna constantly butt heads on this. So I'm curious what your goal is for confidentiality. And I'll share for me, like it is for employment and for education and for work. Like that is the priority for me. I'd be curious to hear from the Defender. Jen, what is your goal for confidentiality?
So it's all of that plus. I mean, I think that all of that plus we want people to be free from social stigma, which is actually a really important part of this. I think that engagement in the community is something that is the motive. When we are able to reintegrate somebody into their community after they've gone through the criminal legal system, we are really able, those are the people who are successful. Those are the people that we are able to be successful with. And as long as somebody's criminal record is easily accessible to anybody with a computer, I think that has caused a real shift in our ability to reintegrate people into their community successfully. I think in the time that I've been practicing law, I have seen my clients have a harder and harder time reintegrating into their community because of the persistence of their records and the fact that anybody with Google, which means any of their neighbors, any of the people in their town knows all about them, knows all about their record, knows all about what happened. And so the social stigma, I think, is important. I think that it's important that we limit the ways that law enforcement uses these records. I don't think that it should be free for all. I think that what's in this bill, which allows law enforcement to access these records when they say, we have a reason to believe that if we access this record, it'll allow us to address something in this case. To me, that is a fair approach, a fair balance. What we don't want to have, because of the studies which show that these records don't have predictive value after a period of time, is law enforcement, for example, walking up to somebody's car on the side of the road that they've pulled over for speeding and immediately starting a drug investigation because they can see that somebody has a drug record in their, a drug crime in their background from 15 or 20 years ago. Those are the kinds of things that we want to take care of. We really do have deep concerns about the integrity of this data in terms of its public distribution. There's a lot of information that is not actually available to the public that is stored in these records. Even records that are public records. We have public defender applications, pre-sentence investigations, psychological evaluations, assessments like that, psychosexual assessments that are confidential within those records, but are still stored electronically in those files. And someday, according to what everybody says and according to what we're seeing around the world, we're going to be hacked, and that information is going to be public if it persists in that form. And that's one of the things we're very concerned about. That contains, when I look up at one of my clients' public defender applications, it's often got their social security number in there. It's got all kinds of very personal information. Psychosexual evaluations are incredibly sensitive and personal. Psychological evaluations, pre-sentence investigations, all of this stuff that even within our public system is kept confidential. And yet we very much worry about its exposure to the public.
Did you have a question?
I did, yeah. And so this kind of goes back to your statement, Marshall, on some of your clients having a difficult time adjusting, once, so I think there's a couple of observations that I have, right? Is that these individuals don't have neon signs on their forehead saying that they've been convicted or have been accused of something. I think there's also the idea of, I think it was St. Thomas Aquinas that said, there are these social constructs, right? And like all of us living in society engage in these social contracts, and that we have to do what is in the best interest of the community. And when people violate those contracts, and some of these offenders have done that, is there not, by breaking those social contracts, is there not some kind of punishment, right? Where society should be able to hold them accountable, and that people should be aware of the infractions that people have committed. So I think we probably deviate on some of that. I think some of the other thing, so I guess this kind of brings me to two questions. One question is, are there any records in your view that you don't think should be expunged? Or should we just get rid of everything?
No, I think there are records that should not be expunged.
What would be examples of those?
So I would base it, and it's interesting because I was looking at other states. And so if you look next door to us at New Hampshire, for example, in New Hampshire, you can expunge almost any kind of record.
But expunge in other states also means seal. So I just want to make sure that we have.
Interrupt each other.
Well, I just want to make sure we have the right definition, Karen. Thank
Just to
you.
be glad, I like the interruptions because it makes me be able to clarify on the spot.
Right.
I'm used to being interrupted because I deal with judges, and when I talk to them, and if I get interrupted, that's usually a sign I'm in trouble. I'm going down the wrong road. So what I would say is, when I say expungement, at this point, I'm talking about sealing or expungement, because while I would prefer that we have a regime of expungement, because I think that's important given data integrity and the challenges that we're seeing in keeping electronic data confidential in today's world. I understand that because we're talking about both current law, which uses the term expungement, and proposed law, which is all sealing, there's really different things that we're talking about. So I'm grouping them together into one thing that I'm calling confidentiality. So to use New Hampshire as an example, they have a provision that provides confidentiality. That's pretty extensive. It's similar to what's contemplated under S12. It is fairly confidential, but still kept and accessible to courts and law enforcement under certain circumstances, but not under any circumstances. And in New Hampshire, interestingly, I expected that their list I actually had an intern. I said, please go through all the states, start with New England, and figure out what is accepted from their sealing or expungement laws. And I expected it all to look a lot like Vermont, where it would be the most serious offenses, murder, manslaughter, sex assaults, those kinds of things. And in fact, a lot of states, it's not based on the seriousness of the offense. It's based on integrity offenses. So in New Hampshire, the offenses you can't get expunged or sealed are things like perjury, dereliction of duty by a public official, obstruction of justice. They have some special law for false statements by law enforcement officers in court proceedings or in court documents. Those were the kinds of things that were not expungible in New Hampshire. Other states go with something more like what Vermont has sort of worked around the edges of, which is saying we're going to focus on the most serious offenses, like the ones that are, the most serious felonies are going to be the ones that are accepted from sealing or expungement. I could see that working either way. I think I can see the importance of both of those sort of kettles of offenses being, having more persistent records. So I would say both of those are legitimate sort of categories of offenses that maybe should not be eligible for sealing or expungement.
Okay, I think we want to be careful and just work within the working definitions that we currently have, and introducing a third definition of confidentiality, I think could just be very confusing to not only the people in the room that are trying to craft the policy, but also the people that are listening. And that's not anything I would say that's to anyone that's introducing a third terminology. And because we already have two working definitions, which we received testimony on yesterday, that aren't necessarily in line with a lot of our peer states, because expungement typically isn't used in other states and sealing means expungement. So when you're talking about these two interchangeable terms and adding a third definition, the machinations are turning, and it's like, we just have to focus on like what's in front of us.
And to be clear, there's actually at least 3 definitions or 4 definitions in front of you.
Right.
You have at least 2 definitions I would say 2 definitions of sealing in front of you, because you've got current law, plus you've got S12. You've got 1 definition of expungement in front of you in current law, plus you have the various versions of sealing and expungement that have existed in prior Vermont legislation that have not passed into law. And then when you compare us to other states, you, as you say, there really are not many states. When you do a 50-state survey, there's not many states you can compare, because almost every state has a different definition and procedure for what gets sealed, what it means when something is sealed, who has access to it and who doesn't. And so it is very hard to compare state to state. But I think it's important to compare state to state. It's just that we have to be really precise when we do it.
Do you think, and it's just an additional follow-up, do you think that the records within, yesterday we were talking about, kind of individual interactions in specific cases, do you think that that provides context to law enforcement of what they could be? I mean, you talked about implicit bias that could be introduced. I'm curious, from my standpoint, I think maybe others in the room, it provides context of like what law enforcement could be getting themselves into when they do a routine traffic stop, and there's a far more serious and nefarious intent.
And I think that's exactly, it is the distinction between context and bias. And I think that's what I'm talking about, is when I see one of my clients' criminal records, I have an instinct my instinct is that that's context. My instinct is, oh, this is providing me context to understand their current charge. But in fact, at the end of the day, really what it's providing me with is information that my brain is interpreting in a biased manner. I'm seeing that and I'm saying, because they have this, I bet that provides me with some information about their current charge. And honestly, most of the time, if those charges are old, it really doesn't. It may be that I have somebody who has done, has committed 2 offenses, but if they're really separated in time, what I really find is I find somebody who has really 2 different life experiences and has gone through 2 different things. I don't find that it provides context, and the studies show that it doesn't provide context either. So that's where, to me, there's an instinct that I think is very natural, but I think that both experience and evidence show that our instinct is not actually accurate.
But do you think it's your own lived experience that's providing that bias?
I think it's my own lived experience, yeah. And I think that
But I don't think we can like draw similar conclusions to all law enforcement to say that it's informing all of their bias. Because I think, even yesterday we had an instance in Rutland County with Austin Rodriguez, who's a 26-year-old serial offender. And if all these records were sealed or even worse, expunged, the law enforcement who showed up on the scene would have no idea in the context that this was a serial offender that was really just a bad actor, a bad citizen in the community.
And, I can't comment on that case specifically, but what I can say is that, in cases like that, there's no proposal on the table under current law, S12 or H762 or any,
Well, 762 is gone. Yeah.
or under any sealing or expungement law that I have ever seen introduced in Vermont. There is none of them that would have allowed that person to have gotten any of his offenses sealed or expunged, because all of them require some period of desistance from offense before you can get a sealing or an expungement. So,
Well,
I mean, I know.
I take issue with that assertion, but I think that's going to deviate far from the subject at hand, so I'm not going to go down the rabbit hole.
I mean, I'd be curious because if I'm reading the laws wrong, these are.
Well, assuming that he did all these when he was of age, right? Like we have now youthful offender protections that were just passed in H2 that provide a lot of protections to make sure that this person, none of these would have made it to court because he was under the age of 18.
No, but those would only work if he was successful. So only if he was successful.
There's a lot of assumptions in all this.
And my point is that in that case, none of those charges would have been sealable or expungible. There's nothing that could have been hidden in that
Possible.
case.
Yeah.
Under any of these provisions, anyway.
Tom.
Regarding law enforcement records and information, could you give me some sort of instance where instinct and bias would be probable cause?
Nope. So I'm still on the scope of the expungement of the confidentiality provisions. Again, current law, when we talk about misdemeanors, under current law, there's 42 misdemeanors that are not expungible. Under S12, that would be reduced to 19 misdemeanors that are not expungible. But under H762, that was down to 11 misdemeanors that were not expungible. So again, this is a case where not the best bill, not the worst bill, but I think it could be improved. S12 offers some control over sealed records. We think that's good, but we think expungement is better. So S12 provides that law enforcement can access sealed records, but must have a legitimate reason to do so. That's an expansion of what's allowed now. What's allowed now is no access to expunged records. There is a provision for access to sealed records. So we do think that this expansion is appropriate because it provides for a court check on that access. If that court check was not there, then we would not feel that that expansion was appropriate. And that's consistent with the law in a lot of states. So a lot of states that don't have expungement, which is what's contemplated here, S12 eliminates petition-based expungement. So a lot of states that don't have petition-based expungement and instead have some form of sealing do allow law enforcement to access sealed records, but a lot of them provide for some check on that. And usually it's through the form, as this is, of some sort of application to the court. This provision, S12 also provides for defense attorneys to get access to sealed records and for prosecutors to get access to sealed records. And again, we think that as long as we are eliminating expungement, that becomes necessary. It becomes constitutionally necessary. So as long as these records are not actually being expunged and are instead being sealed, then we do actually need to be able to provide access to prosecutors and to defense attorneys. So while we would prefer expungement so that we're not expanding the scope of that access, once we're not expunging things, constitutionally we're required to provide that access. So we do support having that in there. And we think that having the judicial check is a good thing that provides some checks and balances in terms of how that confidential information is accessed.
I want to double click on the constitutionality. Are there examples in other states where that has come into play?
So other states have similar provisions. Even if they didn't, It wouldn't matter because there's a decision from the US Supreme Court called Pennsylvania v. Ritchie, which deals with how states handle statutorily confidential files, records of any kind. So this is anything that's not subject to a legal privilege. So Ritchie doesn't apply to files that are protected by attorney-client confidentiality, doctor-patient privilege, priest-penitent privilege, but just things that are covered by any sort of statutory confidentiality, which could be educational confidentiality, child welfare confidentiality, confidentiality in the form of sealing or expungement or sealing. And what it provides is that the Sixth Amendment trumps any statutory confidentiality provision. So if as a defendant, you have a need to get at a confidential file in order to defend yourself in court, you are entitled to that, even if it's protected by a state statutory scheme. It doesn't give you unfettered access. What it gives you is it gives you the ability to ask the court to review the file ex parte. Actually, not ex parte, in camera. So not even with any, so no defense attorney in the room, no prosecutor in the room. The court reviews it on its own, determines whether it's relevant. If it is relevant, turns it over to the defense. If it's not, it doesn't.
How would it, oh, sorry.
Go ahead.
How would this relate to confidential files that have been expunged? That no longer exist but are relevant to the case?
So if a file is expunged, then it doesn't exist and there's no way to get it. So it's actually expunged.
So then can we say that justice has been, and like, I'm just thinking about access to justice. Like if there's a case, if there's a relevant case and the files aren't accessible because they've been expunged, like what if the case is being retried? What if there's new information, new evidence that's being introduced? But all of a sudden, all these files are missing.
So it doesn't present a problem because, first of all, expungements only happen when a case is final in one way or another. It either has to be final in the form of a conviction, or final in the form of a acquittal, or final in the form of a dismissal, followed by the expiration of the statute of limitations. But it can only happen once a case is truly final. In terms of the fact that there's information that may have existed at one point that could have been exculpatory that no longer exists, that happens to us all the time as criminal defense attorneys. As criminal defense attorneys, it's not just that there are legal records that could be exculpatory that disappear. There's records of all kinds that could be exculpatory that disappear. And even with currently, there's a lot of things that are not expunged and simply disappear nonetheless. I have a case right now that I've been working for years trying to reconstruct the record on for a post-conviction relief case because the records only existed on paper and they were in the basement of the Chittenden courthouse at one point when it flooded, and those records are no longer accessible. And so for years, we've been trying to rebuild what
Not
happened.
willfully done. I mean, that's like an act of God, right?
But my point is that it's not something we're not familiar with. We're very familiar with dealing with the lack of records. In fact, as criminal defense attorneys, it's what we deal with more often than we deal with information, is we deal with a lack of information.
So I guess the root of my question is, why would we intentionally destroy records?
And I think the answer is because keeping the records around is more damaging than destroying them. That the purposes that they may serve are very limited, and yet the harm that they may cause is extensive.
So, I mean, I'm just wondering if you're going over more of the scope of the exceptions. Well, no, because I have a question about backing up as far as the court petition process that's in here.
Yes.
So some of the testimony we received yesterday suggests looking into a narrowing when the court needs to weigh in. We heard testimony as far as investigations, for instance, and whether the court needs to weigh in if a police agency is looking actually at their own sealed records to figure out, to do part of an investigation. Right, can you comment on that? Because, I mean, right now it says criminal justice purposes, but there seems to be pretty easy to distinguish between something that is happening in confidence still, like investigations, for instance, and then actually using these documents in court. And I'm trying to understand, or get input on that.
From our perspective, it's important to keep it confidential in both circumstances. And to have that court check to say, yeah, you should be using this for an investigation, or no, you shouldn't. And that's consistent with the way that it works in a bunch of other states. So for example, in Alaska, information that's sealed after a criminal record is sealed, it's accessible for specifically those records, record management purposes, including auditing, criminal justice employment purposes. So not for like a criminal investigation, but for if you're hiring a police officer, they say you should be able to look at sealed records. In that case, for review by the subject of the record, for research for statistical purposes, for exigent circumstances, and for use authorized by court order. And those are their exceptions, and all of those have to go through a judge. In Arizona, court clerks can release sealed records to law enforcement if the purpose relates to the requesting party's internal hiring practices. So that one doesn't need to go through the judge, but it's through the court clerk, but it's limited to internal hiring practices. In Arkansas, it can be released upon request to law enforcement for criminal justice employment eligibility, and then it can still be used in a number of other ways, including for impeachment in court, but not during an investigation. But that's just the first few, and I had my intern do sort of a 50-state list. So there's some version of this in most states. What it looks like differs in every state. This is one of these areas of law where there's really not much consistency state to state, and every state sort of developed their own kind of ad hoc statutory scheme, but they've all got some of the same elements.
Well, let me ask you a little bit differently as well. So what is the concern of law enforcement in an investigation being able to access sealed documents, without a court permission?
So if the documents are sealed because they are old documents of criminal convictions, that they're not relevant. And so we're giving not relevant information and feeding that into an investigation because it's lost its predictive value.
So wouldn't that come out, through the investigation and as you get to the point of being in court? We even need to have the court check it all, because if they're using sealed information that isn't relevant, isn't that what the defense attorney is going to argue?
And that's essentially making the argument that isn't it okay if, no matter how the process starts, isn't it okay if it winds up with a good outcome? Like if it winds up with an okay outcome. And I think, I have clients who wait for years in jail only to be acquitted when they finally get to trial. I have clients who, even if they don't go to jail, they lose their jobs, they lose connections to their family, they lose connections to their community, only to be acquitted at trial, or to have their charges dismissed on the eve of trial. It's not as if being charged, it's not the fact that there's a courtroom remedy available for this does not take away from the harm that's done when somebody is wrongfully prosecuted. It is incredibly damaging to people's lives, their reputations, their well-being, and how they are able to engage in their community, even when they're acquitted of an offense. And so the idea that we would say, let's let this information in, even though we don't, it doesn't look like it has any real validity or relevance, just to me means that we are adding information in that can only serve to steer people into the system, even if there is then an outlet. That process is oftentimes worse than, I have clients who plead guilty to things that I do not believe that they are guilty of, and they are just pleading guilty to end the process.
So back to the investigation, though, you think it's because of a relevance issue. It's not necessarily
Relevance and confidentiality. There's a lot of people involved in police investigations. This information, I have cases that are very confidential. A lot of the space I work in is juvenile court. Some of the most confidential, it's as confidential as court gets. And I am constantly hearing about my cases from people who should not know about my cases, who have information about my cases that they get from professionals who are involved in the work. And I understand that, and I know that, and I know that that's part of the process, and we deal with that as it comes up. But we're talking about sharing confidential information with more people. And when you do that, it becomes non-confidential. And we've seen that over and over again.
Thanks.
Hold on, back to my. So I'll move quickly. I'm not going to bother sharing my screen again because I only have one or two more slides, and it'll take me longer to figure out how to share my screen than just to talk through the slides. So S12 keeps expungement for deferred sentences. We think it's a good thing. That's been around for a long time, and we think that's essentially something that is expected of by Vermonters at this point, is our deferred sentencing scheme and the expungement that's associated with it. And that's also very consistent. Most states don't have a deferred sentencing scheme, but most states have a deferred adjudication scheme. And that also comes with some form of expungement or sealing. So we're glad to see that it's kept there. We do see that this eliminates the expungement for people who are acquitted and provides only sealing for people who are acquitted. From our perspective, people who are acquitted are the people who are most deserving of expungement. An acquittal is a sign you shouldn't have been prosecuted in the first place. We should not be eliminating expungements for people who were acquitted.
So I can kind of see that, but I'm actually more concerned about the deferred sentence that continues to have expungement, because that also has no distinction on what the underlying offense is either. We had testimony yesterday, I don't know if you watched any testimony, that over 800 deferred sentence cases involved domestic violence, for instance, which concerns me if those records are expunged as opposed to sealed. So, but what is the rationale for keeping expungement as opposed to moving for sealing for deferred sentences?
I think to begin with is its legacy in Vermont. Deferred sentences have been around longer. The expungements for deferred sentences have been around longer than any other type of expungement that I am aware of in Vermont, at least since the 70s. And it is really sort of baked into a lot of our court procedure at this point. I think it would be a lot. The deferred sentences are a way that we are able to resolve a lot of cases that would be very sensitive and difficult cases if they went to court. It's why it's used in a lot of cases involving things like domestic violence, where the parties might disagree, but might not want to make their case into a public spectacle. And a deferred gives you a way around that. And I think that what you would wind up with if you took away expungement for deferred sentences is a lot fewer deferred sentences and a lot more of those cases being contested and going to trial. And so we think that it's really valuable because it allows us to settle very, very difficult cases within the.
But I guess, I mean, you deal that they're achieving the same confidentiality.
They are not at all. Sealing is not at all the same level of confidentiality as expungement. It's accessible to law enforcement. The way that sealing would be in S12, sealing doesn't even come close to the level of confidentiality. When you get something expunged, every agency that has a record of it has to destroy the records of it, and then nobody has access to it. It's not available on the computers, it's not available anywhere, and it's not available to defense attorneys, it's not available to prosecutors, it's not available to law enforcement. It's nowhere near the level of confidentiality.
I misspoke. What I should have said is that the person at the end of that deferred sentence will be able to say they have no criminal record, whether it's expungement or sealing. And isn't that what the motivation is for going, one of the motivations for going with the deferred sentence, is that if you fulfill that, you don't have a criminal record.
Maybe for some,
call it sealing or expungement.
maybe for some people, but what we explain to people is we explain, here's what, the prosecutor has offered you a deferred sentencing agreement. Here's what will happen. If you complete this agreement, then you will get an expungement. Here's what that means. And we explain what expungement means. We explain that it means the physical deletion of your records. And that's what they agree to. If we say, if you do this deferred sentence agreement, your record will not be expunged. It will not be deleted. It will still be accessible. It will be accessible to law enforcement under certain circumstances. It will be accessible to defense attorneys under certain circumstances. It will be accessible to prosecutors under certain circumstances. It will live electronically on the court's computer system, prosecutor's computer system, defense computer system, DOC computer system, and any other computer system that your file has interacted with. And it could be accessed by any people who have access to those computers unlawfully, but could be accessed by anyone who has access to those computers. And it could be accessed by anyone who hacks into those computers. Would we have as many people agreeing to deferred sentences? I don't know.
So the way that I took that is that you would be explaining sealing as a negative thing and not a positive. That's just the way that I took it.
We would
So
be,
you would would you bring it up as you would actually say your records will not be expunged when it wouldn't even be an option? Or would you say your records can be sealed and this would be the benefit of sealing?
we would tell them accurate information. We would tell
Right.
them,
Oh, yeah.
we would tell them you're going to get, if here's deferred sentences you may be familiar with because you've been in Vermont, they've been around Vermont for as long as most of us have been alive, but they're no longer what they were. So if you think that they lead to an expungement, they don't. They lead to something else, which is sealing. And we would explain what sealing is and what the difference is between that and expungement so that people understood what the legal consequences of the agreement that they were making are.
So if expungement wasn't in the conversation, you'd still bring it up?
Probably because most people who are in this situation are familiar with what a deferred sentence agreement is, and they have to have explained to them that the law has changed. Because currently under the law right now, if I go into court today, and if I get a judge to accept a deferred sentence agreement, there's an expungement at the end of the line. That law would change, and so we need to explain that change in law to our clients.
So if that's the case, that this is, individuals are kind of coming back into the system. They've had a deferred sentence before, and they're coming back. How would, well, that's kind of what.
Deferred sentence before, I'm saying that people in Vermont understand what a deferred sentence is. It's been part of Vermont law since the 70s. It's part of a lot of Vermont cases. A lot of my clients, typically I don't have clients who get more than one deferred sentence. So
That's a relief.
It's not.
Maybe you would know, but I guess how would one know if the documents are expunged that they're coming back for another deferred sentence?
In general, first of all, people just know because we have the same people practicing in the same courts for years. And also, most of the time, the deferred sentence extends beyond. So there's deferred sentences with the agreement of the prosecutor and deferred sentences without the agreement of the prosecutor. And most of the time, if we are getting deferred sentences that are at all a challenge, it's only with the agreement of the prosecutor because it's in those challenging cases. And in those cases, the prosecutor seems to know, even when there's been an expungement. I haven't seen people getting multiple deferreds. My clients certainly haven't been getting multiple deferreds.
Yes.
I just come back to the phrase that they just know. I mean, that seems like a really poor records keeping policy. And it seems like something like, well, number one, it's a man rest or a woman rest. You have institutional knowledge that's going to go out the door eventually when these people retire. I just think that is a really almost like a flagrant. I'm not even sure how to totally characterize it, but I think that phrase, they just know, seems like a pretty dangerous path to go down.
I understand that. And the fact is we've had basically the same deferred sentence framework in law in Vermont for decades and decades. And it's been functioning the way that it's been functioning without complaints from really either side for those decades and decades.
That doesn't mean it's right.
I actually would say it does mean it's right. The fact that it's working without failing is a sign of success. If we had people in here every year saying deferred sentence agreements are such a problem, that would be a sign that they're not working. And instead, In fact, deferred sentence agreements are something that I think both prosecutors and the defense, we've expanded them over the years. They started out only available in certain circumstances, only available at certain ages. And with both prosecutorial and defense support, that's expanded because we both see it as a tool to resolve very sticky cases. So finally, S12 moves backwards on automatic confidentiality. So currently, the expungement of qualifying offenses committed by people age 18 to 21 is automatic. Under S12, that would become petition-based and sealing only, not expungement. We think that moving towards automatic expungement is a really good thing. Age 762 from last year had an entire new framework for automatic expungement that we thought was a really good framework to start from. That's what other states are looking at, is moving towards automatic expungement in a broader sense. And so we think that it's not a good step for this bill to move backwards on automatic expungement by taking one of our automatic expungement provisions and turning it from automatic to petition-based.
Which one is that?
That would be on page, hold on, it's near the end. It would be page 31, the amendments to section 7609. If you see at the beginning, it starts out by adding the word petition in, and then it goes on to describe a petition procedure where before there had been a petitionless procedure.
Okay.
And that is, oh,
Any other questions for Marshall at this point?
I
Here,
have
let's-
your PowerPoint on the web page as it's shared with Nate.
I can send it, Nate, I only finished it 5 minutes before I did not share it with Nate. I don't know.
I appreciate that. And certainly if we modify things, we'll, as I suspect we will. And let me ask you one question that has come up from other testimony as well. And this is back on the whole petition issue from the court. It's on page 25. We've heard from a couple people who have pushed, and I assume we'll hear from more, that access in subdivision C2A should be use, not access. That individuals, yeah, they wouldn't know. Presumably, they already have access to sealed documents, and they can understand whether it can be relevant to whatever they're looking at, and then they can decide, well, they need to petition for use.
Certainly would support that. I mean, that's making the presumption that we're giving access to everybody, at which point, why bother sealing it in the first place?
It's not access to everybody, it's to the criminal justice agencies.
Well, it's pretty broad access, and at that point, you know, if we're saying you can just sort of go through these records, and then once you want to use something, like you can paw through the records as much as you want with no court check on your access to it, no restrictions on your access to it whatsoever. And then only when you decide what you want to use, does somebody step in and say, is this actually relevant, trustworthy, should it be used or not? I would certainly oppose that.
So there's different scenarios here. I mean, that there could be a state's attorney or law enforcement, and they have these records. They have these records that are now sealed. You know, they're in their file cabinet. They're in Belcorp. And I don't see why they should have to petition the court to look at those records. My understanding as well is that, at least in Belcorp, that it can be, you know, the sealed documents can be partitioned, so it's only the agency that can look at it that created the document. And I could see, my understanding is if other agencies want to access those documents, they have to get permission from the agency that is holding those documents. It's not like there's unfettered access from what I understood testimony yesterday, including also from criminal justice records that are held by VCIC. So
what we would want is we would want whatever those fetters are to be in law, and then we'd want to be able to evaluate them and tell you what we think of them. Because if what we're saying is they can access all of this, and there are some restrictions, but we're not going to tell you what they are. And they might vary from agency to agency. And it might be that they can be shared within agencies, but then between agencies with agreements. And to me, that's very scary. What you're saying is we don't actually know what the access looks like. And we're proposing to provide access without knowing what it looks like. And it may vary. So whether or not we would support that, I can't tell you until I see the language, because what you're saying is, can we provide access but not really describe what that access is? And my answer would be no. Like, if you're going to have confidential records, you got to be clear about who can access them and when and for what purposes, and not leave it to just say, we let that be figured out internally. If there's going to be constraints on that access, which this bill provides, and we support the constraints that this bill provides, in terms of us weighing in on other constraints, we'd have to see what they looked like. And we certainly would not be in support of anything where those constraints are unknowable, where it's just like, we're going to allow access, but we're not going to define what access means. That we would not support at all. Because there we're just basically opening the door to confidential records and saying, we're not going to have consistency around the state. We're not going to have an understanding that anyone can look up and see what it is. We're not going to be able to advise our clients, because our clients, we're going to have to say, we don't know. Policies could change. In terms of who can access your records if they're sealed, that could change based on which agency has the record, who's in charge of that agency, whether their memorandums of understanding with other agencies change, whether they have memorandums of understanding with the changes. We wouldn't support that, because that gives us nothing to advise our clients about and no consistency. So yeah, we'd have a lot of problems with that. If we're going to say that there's some level of access that's allowed, we would want that very clear. And then we could look at that and tell you what our position is on it.
Is it going to be burdensome for the Defender General to access, I mean, presumably you're going to have to go to the court to access your own records that you have that are sealed on clients?
Yes, we already do that. We don't even, if we were to get into a position of having to access a sealed record of a client of ours, it would probably be a situation where we should be conflicting out of the case in the first place.
Any other questions for Marshall? Oh, yeah. Sorry.
I was just you didn't see the testimony yesterday when we talked about the law enforcement agreements, so you're gonna, that's all.
All right, thank you very much, Marshall. Appreciate the testimony. So, yesterday I took a 5-minute break and we went to 25 minutes. So I decided that we weren't going to do any more breaks this session. So we're going to go to Judge.
I just did some research on breaks,
Oh, yeah.
and they are very, very.
Well, can we be back?
I'm just saying, I'm going to forward you a couple of videos. Because I know they're a hindrance to you, but.
No, they're not a hindrance. It goes for 25 minutes instead of 10. I mean, if we come back in 10.
I think it'd be worth doing research.
Can you use your seat?
Absolutely. A beneficial break.
Well, I'm sure they.
Okay.
Good morning.
Well, I'm not the one that's not allowed to operate.
I just want to keep clarification on.
That's coach's issue.
Of our license.
Help yourself, Lars. Oh, thank you.
Sent to transportation.
Good morning, Tom Zone, Chief Superior Judge.
State Court Administrator.
Thank you for being here.
So, if Terry, if you want to hear from Terry on the court administrator side of things first, I don't.
Sure, that sounds good.
It's fairly brief. From the court operations perspective, the sealing process is very similar to the expungement process. So this would not impact the court in terms of time involved for cases that will qualify. I just wanted to let people know, I know that I think in Senate Judiciary, there was a conception that perhaps the sealing process took fewer steps and was a shorter process, but that's not the case. They're very substantially similar. In terms of impact on the court, we're not really able to project how many cases or how many petitions would resolve and what the impact would be. We always do ask permission to reserve the right if, for example, or the option if it turns out that there's a huge increase in cases because of this, petitions, et cetera, then that would come into consideration when we submit requests for additional resources if we get to that level. Just to let people know. Otherwise, we're able to comply with, for example, the impact that it would have on the public portal or access if there's a sealed record. We have right now mechanisms in place so that it's not publicly accessible. You know, we're able to monitor that and to, you know, implement whatever coding is needed for that to be accomplished.
So is it gonna get easier as we go down the road? Because right now you probably have paper records that would still have to be dealt with, and is it easier to deal with sealing paper records than expunging them, or is that same amount of workload?
I think the process all the way through is very similar.
Okay.
I mean, in the paper world, for example, if it were an expunge case, then there would be a physical shredding, for example. We wouldn't have had that with the sealing. So I
Right.
guess there's that distinction. But at this point in time, you know, the vast majority of the cases are electronic. Again, conceivably, there would be occasion to have a paper file that would need to be, you know, sealed and or expunged. But I think when we look at it statistically, we had the biggest run on that with the, whatever the act.
167.
The old marijuana, that was, you know, a huge chunk of going back and finding old, you know, cases, but I don't know that we have that situation.
They're up in smoke now.
I'm sorry. I had to take that. Was that okay?
You were waiting for.
I was waiting for that. 3 years of this now.
As long as
We all got there.
at least the main thing, right?
It's the counties that primarily had colleges, that were most impacted by those cases. The 70s marijuana cases, so.
Any other questions for Terry?
Thank you.
Okay.
When the courts have a record that's sealed, are some still paper and some, or are they all now?
Well, anything that came in before the Odyssey, which was in 2020, those are paper and the closed out files are paper.
So it's basically now going forward mostly electronic.
Yes, although I guess we technically would have some cases still in paper, although what we're doing is if that happens, it transitions to electronic. I mean, so that it goes forward as an electronic case.
Electronically, what happens to a record?
There's a coding for it. It's got a confidential coding. So it's
With
not,
access.
within our IT department, the people with the special access would have it.
It wouldn't be at the clerk level or,
No. And there'd have to be permission, you know, for whatever the permission was for access, and we would go through that, the people that have the.
this is a record that, this is the one that, Attorney Paul was earlier speaking about, that would have things like, public defender request forms and sexual evaluation forms and things like that. That this is where all of that is gonna live. This wouldn't be necessarily the same as what a law enforcement would do.
It would be only the person with permission, which is very limited.
But I just mean, there's gonna be a much larger scope of information available at the court level, I would assume, in that.
Well, it's currently an Odyssey. And so when you, for instance, when you look at the Odyssey structure, you have your summary, and then you can go into documents. So when you look at those documents, it starts off with the information affidavit, citation. So every document comes up. And if it's a sexual offense, you would have the psychosexual. They're also, when they're in there, they actually, day one, they have a special category of being sealed from public access. And so they're sealed then. What happens when there is a sealing is that entire file, everything goes behind another wall.
Right. I guess what I'm saying is I'm comparing it to the law enforcement side, like the Valcourt side. And when we handle a case, we're not going to receive all that information back, that giant pile of court documents that has the whole global case in it. We're only going to have the initiation part, or the initial part, the investigation, and off it goes.
I guess in answer to your question is the very limited number of people on one hand who would have permission to access that. And they would only access it if there was an inquiry from the court.
And you would only send some sort of disposition or completion sheet back to us, or would that come from the state's attorney?
That would, I would imagine, come from the SA.
All right. Judge Zomick.
So expungement versus sealing policy. It really, it's a policy having, I know that the legislature for years, back to my predecessor, has been going in a direction of universal sealing and having sealing as how we go forward. That's a policy that is up to this committee and the legislature as a whole. When you asked before, Chair Lalonde, you were talking about the deferred sentences, and that's not part of this bill. It was part of the bill last year. That's a I would know that's a policy also. And the determination of whether you go with sealing or expungement for deferred sentences, if you went with sealing, the only thing I would ask, as I did last year, is to make sure that you take care of the situations where people have already received a deferred sentence with a promise of expungement. And so it should be sentences, deferred sentences imposed on or after, so that there's a date going forward, so that we don't run into any constitutional or other contractual challenges that, well, you can't go back and change what was an expungement agreement to be sealing. But whether it's sealing or expungement, that's up to the legislature. And I know Mr. Paul talks about the fact that some people may not take it. You know, the options for someone are go to trial and have it not sealed, or you can be convicted or you can be found not guilty, or go to a deferred sentence. And whether it's an expungement or sealing, it's sealed. And so that is the determination for the parties. And I may have my experiences and views on whether or not that's actually going to tell people I don't want that, but I'd leave that to the witnesses from the field.
As a judge, is there situations where you go back and look at records for whatever reason?
Sealed?
Yeah, they'd have to be sealed because you can't look at expunged records because they don't
So I'm
exist.
saying, you mean sealed records as opposed to other types of case records that are currently accessible publicly?
Yes.
Yes, my role is somewhat unique. So as the statute talks about, there's times I may have to look at sealed records for purposes of research permissions. So mine is unique there, but there are times where courts may need to review. There might be a request by someone to see a sealed record or a confidential record in juvenile case. And sometimes the judge may have to look at it to see, are they someone who actually fits for access? So there may be times that we have to to look at it to serve properly as the gatekeeper.
Judge, I just am curious anecdotally, how many examples do you find in your day-to-day where there are expungements or sealings in, say, a given year? Like, is it something that's super prevalent, not very?
Well, when you say day to day, every day we're doing expungements and sealings in the courts. We have, there are automatic sealings if someone has charges dismissed as part of a plea agreement.
Yeah.
60 days later, they're popping up on our Odyssey. So it is part of a judge's daily work to review petitions for expungement and petitions for sealing, or just doing what we'll call the automatic sealing because an event has happened and we have an obligation to do it. As far as the numbers, CAO has those numbers.
Yeah.
And it's really, I mean, it could be tens of thousands. in
Oh,
all
wow.
honesty.
Wow.
But I'm just asking you to send last year how many expungements.
That'd be great. Yeah, I'm just curious, Terry. Thank you.
So do you have any way of knowing, if we change the ceiling, if that's gonna impact the number of individuals doing deferred sentences? I think I know the answer to that, but.
No, but again, the defendant, you can ask attorneys, the defendant, it really has to make the decision, are they going to go to trial and have no chance at sealing or expungement at that time, or is this an offer that is acceptable? So, whether the nuance of sealing and expungement and the potential use under sealing under H12 is something that's going to have a defendant say, I don't want that. I don't know about that.
Okay. So did you have more testimony?
I just would note that in the Senate, there was quite a bit of talk and looking at these exceptions. And so if you have any questions about them, I know that this was an area that was added and is different from the bill that this committee put out last year.
So I guess my question with respect to, this is page 25 and it's subdivision C2A. I don't know if you have a viewpoint on access versus use is one question. And then the other question I'd have is how much of an impact do you anticipate that this would have on the court as far as the court dockets?
Well, currently, we don't know how much they may use them because under the existing statute, they can use them without coming to the court.
Right.
And so this change is actually more restrictive for the criminal justice agency because, as you point out, access is different than use. So I don't know how many times we'll have them coming to us saying we want to use this. And then we get into the question of, well, what do we mean by use? A law enforcement officer goes to the state's attorney and says, look, I remember a few years ago, this person had this and you're investigating, let's say, a homicide. And the prosecutor goes and with the law enforcement officer, let's say, they look at it. And the question is, okay, now they've accessed it, they've reviewed it. Can they do anything with it? Can they use it to form the basis of a request for an inquest? That would be use. And so do they have to come to court every time they want to do something with it? Is it use? If based upon what the law enforcement officer sees in that sealed record, they want to go down the road and check out a house from years ago. I don't mean to, to come up with these far out things, but in my mind, that's the question that will have to be answered. And do I think it would be appropriate to have every time they want to use it, come to the court and say, I want to use it because I want to go check out this house. Or I want to use it because I want to go look at this level of investigation or this person. That might be a little too much.
So would it be any better if it said access or same, I would assume same problem, same issue that you just suggested, whether it's use or access, or is it easier?
Right now, it just says they can use it. And I'm unaware of any issue I'm unaware of any filings being made saying that law enforcement has used it for an improper purpose for existing sealed records. That a marshal may have ideas about that. The state's attorneys may be aware of that. Law enforcement may, but I personally have not been made aware that there have been problems with that current section.
So are there any restrictions as far as using sealed documents in open court?
Right now?
Yeah.
They can't be used.
Right. So under this.
Let me rephrase that. There are times that we can use sealed documents, but that comes up under constitutional or other protections. But right now, we generally don't have sealed documents being used in court. There are restrictions that come up if you have a deferred sentence, and as part of that, there may have been a suppression motion, and you want to cite that suppression motion. Well, there's a question as to whether you can actually attach that to your pleading, and this new language addresses that.
You would have to go to court to get the permission to do so.
Generally, you would have to have the judge say you can use it. Some judges may say, well, I have the authority. Yes, you can use it. Some judges may say it's sealed. I don't have the authority to allow you to do that. It's not one of the listed exceptions.
Do you have the fiscal year 24 expungement and sealing numbers?
Yeah, thank you.
And to your point, it actually, the large number, when we had the Act 167, that there were, I think, a total of 14,000 for that. That was all completed before this.
Okay.
So for fiscal year 24, there was a total of expungement and sealing cases, 9,324. The breakdown is adult diversion expungements, 1,461, deferred sentence expungements, 339, non-conviction expungements, this is the largest, 4,591, sealings, 2,005, petitions, 880, and then expunged youthful offender, 48. So a total of 9,000. And I can send you that.
Yeah,
Thank you, Terry.
Yeah,
Is
I'll send it to me.
the non-conviction number including where you have like in a plea agreement where they dismiss some of them and the 60 days after, that's in that number?
Probably.
Yes, that should be.
Yeah.
Okay, that makes sense. All right.
And so there are times where the law permits the use, using, I believe, in DWIs for predicates and things like that. There are times you can use them, but unless it's allowed.
But right now, under current law, those 2005 sealed documents that we just heard about can be used. There's not any restrictions other than being used in public, or I'm trying to make.
No, they can't. If something's sealed, we're not using it in court unless there's an exception allowing it to be used.
But for other criminal justice purposes like investigations, apprehension, detention, there's not a restriction on.
Correct.
on use.
The statute currently allows it to be used for those purposes.
Okay. Yeah, Tom.
Are you aware of it being a problem?
No. I personally am not. I have not heard that issue.
You think discovery and a lot of other things prior to has any impact on that, or it just didn't even get that far?
I can't say. But again, I haven't been told that law enforcement is somehow abusing any access that they may have.
I can see that there's some confusion maybe in it because, what we use, like, go back to Valcor as an information database where, information is intelligence, and we use that to find out links and people and associations and things like that. But I think it sort of runs afoul when we talk about it when there is a sealed case attached to a person. And that sealed case is only that one conviction. I think it's hard to separate the two when it's living in a specific database.
I think you're correct.
So just looking at the current definition where it says without limitation for criminal justice purposes, as defined in 20 VSA 2056A, I'm looking at that right now, and it does include adjudication, which would suggest that it could be used in court by, as one of the criminal justice purposes. But from what I understand, you're saying that is in fact not the case.
If you look under C, exceptions, notwithstanding, an entity may continue to use it for any litigation or claim arising out of the same incident or occurrence or involving the same defendant. Under 7607.
So this is under the bill or under current law?
Under current law.
Current law, okay.
7607.
Yeah. Oh, 76, all right, yeah, I'm at dissemination of criminal records, that's the definition of criminal justice. Okay.
This tells the effect, and then it says exceptions. C1, an entity that possesses a sealed record may continue to use it for any litigation or claim arising out of the same incident or occurrence or involving the same defendant. And then under C2, a criminal justice agency may use the criminal in accordance without limitation for criminal justice purposes. And then it says a sealed record of a prior violation shall be admissible as a predicate offense for the purpose of imposing an enhanced penalty for subsequent violation. And you're looking back under criminal justice purposes, correct?
Yeah.
That issue is one which I think I cannot really get into too deeply because I think it is one that would be an advisory opinion. But what I can point out is that in the specific sealing statute, it tells you where you can use it, the limitations.
Okay.
And that is not as broad as the general statute for criminal justice purposes. And so there certainly could be arguments there that cannot be used for any purposes except what is under the 7607. And then there may be arguments that, well, it says adjudication, so we can use it for any purpose.
Other questions for Judge Levy? No. So thank you so very much.
Thank you.
So at the good wise counsel of the vice chair, we will take a 10-minute break.
20. Brian has posted that chart so that